subject, a Mr. Dion Shutter, a well-known figure in the city, recently brought to my attention on the 2nd of March of this year. Charges against Mr. Shutter were extensive. For instance, 2 counts of bank robbery.
Do you want this the easy way or the hard way?
Where's your mate gone?
What mate? What are you talking about?
1 count of shop robbery.
Do not move!
Oh, you naughty, naughty boy.
Counts of fleeing from the police.
You can't use tasers, boys.
Shut up, you little muppet!
Encouraging or assisting a crime. 2 counts of kidnap. 5 counts of assault on the emergency worker.
Get sit the fuck down. Shut the fuck up. You do shit, you muppet. Do you want some as well?
2 counts of attempted murder of a police officer. 2 counts of conspiracy to commit murder. Theft of a motor vehicle. And resisting arrest. Now, as you can see, there's a list and things are not looking good for Mr. Shutter. However, there is defence. Looking at some of these cases, prosecution provided little evidence to support them. For instance, a charge of kidnapping, there really is nothing. The definition of kidnapping is the taking away of a person by force against their will. There was very little. There was 1 video showing Mr. Shutter attempting to escape from his cell by using an officer as would be a hostage. So therefore a charge of hostage taking would have been more appropriate, as the definition of hostage taking is the seizure of an individual against his consent, coupled with threats to that person in order to compel a government authority or third party to act, which this would have been wholly appropriate. So the police force applied the wrong charge here, so there is defence from that. Conspiracy to murder, there's absolutely nothing whatsoever provided by the prosecution. Attempted murder times 2. Now, to commit murder, you have to have a preconceived intention to murder. There was none. Any cases where an officer was threatened to a spur of the moment is not murder. Bank robbery times 2. Well, for a start, we only have some footage of 1, and it doesn't really show a robbery. It shows a man in a bank when the police arrived. This doesn't amount to robbery. Resisting arrest times 2. Very little. Running from police is shown. Resisting arrest is not really the same thing. For a person to resist arrest, you have to state that they are being arrested. So when you look at it objectively, things look slightly better for Mr. Shutter. So on speaking to my client, I encouraged him to enter guilty pleas to charges that had irrefutable evidence, such as running from the police. And everything else, not guilty plea was entered, and we will have our day in court. In court, both myself and the prosecution will be able to examine evidence and witnesses in order to present the case to the jury. Defence only has 1 person to call, the defendant. I had been working on a second, but time constraints proved this to be impossible. Well, more on that later. Prosecution has 3 officers. I expected these to provide statements that, in their eyes, supported the charges brought. Fortunately, they were not asked to, so prosecution assisted me on this occasion. However, there was much to do. I did not wish to get into a discussion with these witnesses, as it may give them the opportunity to win over the jury with their version of events. So, instead, my best course of action lay in discrediting their processes. From this standpoint, I could argue that evidence not in line with charges issued. The first prosecution witness was Sergeant Romanov. This officer had the longest encounter with the defendant and was responsible for authorising many of the charges. Fortunately, I was able to use material disclosed to myself by the prosecution in order to discredit this witness. Officer Romanov, I believe your first encounter with the defendant was in the police department post his arrest at the bank. Is that correct?
I cannot confirm nor deny why he was in custody. I can confirm that, yes, my first encounter was responding to a panic button in custody, as stated, in my statement prior. However, I do not have any confirmation regarding why he was in the cells originally, nor do I have any prior evidence or knowledge of it. I only responded to the panic button, to which both my officer and Mr. Dion were on the side.
I see. And did the defendant state to you that he was hurt and required medical attention?
I cannot recall at this very moment. However, I do believe that he was, as you would say, crying in pain. So I took both him and the officer to NHS.
Immediately? I must remind you, you're under oath?
Yes, as soon as I arrived to the panic, I took the officer to the car, and then I took Mr. Shutter to the car, which you can attest with my body cam.
And yes, we've reviewed your body cam, and this will be available for the court if necessary. It quite clearly shows yourself leaving custody with the echoes of the defendant crying in pain and requesting to go to hospital. Do you have anything to say?
He was in the vehicle with me.
Eventually, yes. You placed the defendant in the back of your patrol car, is that correct?
Yes.
Alongside an officer?
Yes.
And which officer was this?
Mr. Jamie Smith.
The officer that had purportedly just been attacked?
Yes.
Is that correct police procedure?
If you are questioning regarding transport of both suspect and officer, I was the only one on scene and available to transport both of them, and NHS was unavailable to come to the scene, so either I was going to transport them both, or I was going to, transport one or the other.
I see. Well, I put it to you that was an irresponsible act, and it shows negligent treatment of both the defendant and an officer. Moving on. En route to your hospital, your footage quite clearly shows a road traffic accident which you left the scene from. Is this also a normal police procedure? At the hospital, the defendant stated that he was worrying about being taken away from caring for his nan. Do you recall?
I recall, yes.
Do you recall your reply to this?
I recall my reply being that if he is the carer, that he also has several other options. The defendant, I believe, was pleading that he is the only carer at the time, to which obviously both me and Mr. Smith have recommended that there can be another carer assigned, maybe a medical professional, and that she can also be admitted into a institution if so need be by social services due to the fact that he will be going to jail.
Well, Officer Romanov, I put it to you that there was no such evidence for this statement. In fact, what you did say is you should have somebody else take care of her, not a criminal. This is backed by video evidence.
That is true. I do recall saying that.
A criminal, so that there's somebody that, I would say, would be innocent until proven guilty. Is that not the case?
That is the case, and if you have viewed the defendant's record, it is quite long, meaning, yes, he already is labeled as a criminal.
I see, I see. We're in the business of labelling people, are we?
Not really.
We'll move on. Your drive back to the police department. I believe this is where the defendant incurs the charge of attempted murder of a police officer. Is that correct?
On the drive back, yes.
I see. In which case, can you explain how the defendant incurs the charge of kidnapping?
Obviously, the officer is being held against this rule. Technically, he could not be moved, nor could the suspect be moved due to the fact that they were kind of locked in together.
And was he kidnapping him or was he murdering him? There is a difference. The defendant was being pursued by officers on foot. You state that he was tackled.
Yes.
I put it to you that he was not tackled. He fell, and he fell down a flight of 5 stairs, leaving blood on the pavement, and was screaming in agony. Do you recall this incident?
I do not recall this incident, as there was no stairs from the location where we were chasing him. It was by apartments near the construction
Officer
as
Romanov,
well.
this is on your video evidence.
I understand that, but I do not recall there being any stairs during the time of the chase. And as stated, I do believe he was tackled.
I see. Your Honour, may I approach the bench?
Yes. It's fine.
How would you like to proceed on this, Your Honour? We have video footage that can be presented. It would take some time, as it would need to be edited and put on your screen. So it's really entirely your call. I do have the evidence. I just cannot present it straight away.
Right, that's fine. I'll join the call for 10 minutes. You want to prepare that?
Certainly. Thank you. Regarding the tackle and subsequent treatment, I submit video evidence taken from the sergeant's body cam.
Yep, that can play whenever you're ready.
Grab him, grab him, grab. No, don't. He's already in handcuffs.
No.
Fuck.
What the fuck?
As we clearly see here, no tackle has taken place. The PCSO is in a standing position, watching the defendant fall, and as I explained before, leaving a pool of blood on the pavement, clearly crying out in pain whilst being wrestled by your PCSO. Now, as a serving police officer, clearly you're expected to ensure that there is evidence of a crime before you bring charges. Is that not so?
That is so.
I see. I have a voice recording taken from surveillance in the police department, and it details some radio communications. I'd like to play it to the court.
Yep, that's fine.
I ain't got body cam of any of the stuff that happened with you.
So clearly evidence is not present in this situation. So what would you do in this situation?
Would you maybe like to play the full recording as to get more context?
And the full recording merely states that you don't have footage of certain offences, which we'll now see in the following video, which I'm about to submit to the court.
But the bank robbery, he did admit to it in the car, so I guess we can count that.
I see. Do you often guess, Sergeant Romanov?
Objection, leading.
Sustained. Move on.
I'll reword the question. Apologies, Your Honour. Did you guess when you issued charges of conspiracy? There was no evidence whatsoever to show any conspiracy.
As we have clarified before, the conspiracy to murder are charges in place for him threatening us during his transport to NHS.
As
There is not an official charge for threats or threatening a government employee.
And I'm sure there are charges for every crime. It clearly is not conspiracy to murder. Let's move on to encouraging or assisting a crime. I believe you brought this charge as well. Yet we are absent of an actual crime. Encouraging or assisting which crime exactly?
Encouraging his friend at NHS to help him escape, which in turn he said that he will do, and proceeded to get in the vehicle that Mr. Dion was being transported in, and drove off with Mr. Dion in the back of it, which you have evidence of on my body cam.
I'm afraid this evidence was not submitted by the defence. I have no evidence of this whatsoever. The second witness was Inspector Blade. As part of the prosecution evidence included video footage from the officer's body cam. This showed an incident in custody resulting in the defendant being shot by a firearms officer. All I needed from this witness was for him to stand by his video evidence fully. I had no further use for this officer, so my cross-examination was concluded quickly. Officer Blade, I have just one question for you. You've submitted evidence from your body cam as evidence for the prosecution. Is that correct?
That is correct.
And you stand by everything on the video. It is complete and correct to the best of your knowledge.
100%.
Thank you. That is all the questions I have for this witness. The final prosecution witness was PC Callum Quarmby, the firearms officer involved in the custody incident, which culminated in the defendant being shot. PC Quarmby submitted his body cam footage as evidence, as one would expect. And upon viewing this, I noticed a concerning discrepancy between his and Inspector Blade's submission.
Before he gets out, Quarmby.
Come on. Next door.
Gets out, Quarmby.
Come on. Next door.
This would form the goal of my cross-examination, but to successfully illustrate my points, I first needed the officer to confirm his footage was accurate and reiterate his detailed account at the moment he pulled the trigger. This had to be approached skillfully, as the direct questions would show my hand, so to speak. Once this objective was reached, I revealed my concerns and successfully inserted reasonable doubt into this evidence and statements given. Officer Quarmby, I want to talk about the situation in custody where you were forced to open fire and subdue the defendant.
Mm-hmm.
I have here body camera footage that you have submitted to the court, which is taken from your camera at the alleged time. I'd like to play this to the court.
Yep.
Mm-hmm.
Unlock every door for me.
That is not going to happen
Go on.
because
You
you have
guys?
an officer
Go on.
hostage. The door is unlocked.
Okay.
We will
Now
let
this,
you
right,
out,
you can.
but the tasers are not
Not
going
today.
down
Tell me.
because you're threatening an officer. Simple.
That's fine.
Not if you can get
No, hey, everyone stay. No surrounding. No funny business. Open that next door and walk away from it.
You've got my permission to take shot. Make sure it's a clean shot.
Before he gets out, Quarmby.
Come on. Next door.
Is he shot Robinson?
No.
Nice.
Officer Quarmby, can you just talk me through the moments, just the moments leading up to you firing your shots?
Yeah, so I believe I received a dispatch call for a panic button, and over radio we were requesting for Trojans to come down to the custody cells. At the time I was the only Trojan Trojan officer available other than Robinson. Obviously Robinson was hostage at this time, so I came down. When I got down I didn't really know what was going on aside from Robinson was hostage, so obviously I tried to get a handle on what's going on, so I tried to control the scene. But due to what Dion was doing, wouldn't really give me a chance. Obviously, yeah, Robinson go over radio, but I've got authorization to take a shot. Kept an eye on what Dion were doing, wondering whether I should take it or not. Doing a little risk assessment, seeing how many officers are about, seeing who's in the way, etc. Then thought, if he's obviously if let Dion out into public, it could put public lives at risk. He's also got an officer's life at risk. And Dion is known to take officers hostage and putting the public in genuine danger due to his previous history. So I felt it was necessary to take the shot to keep the officers safe and the public outside of the PD safe.
I see, I see. So you were fearing for everybody's safety and you did your duty.
Mm-hmm.
Now, when you lined up to take your action to bring the defendant down, you pulled the trigger, and what happened from there?
Well, it went down.
I see. Where did you shoot the defendant, officer?
I believe it would have been his right shoulder or left. Right. Yeah, right shoulder.
I see, I see. Your Honour, I'd like to submit another video. This is taken from Officer Blade's body camera, and which you heard earlier. He stands by 100% as a complete and accurate account of the events.
Yeah, that's fine. You may play.
Is there any Trojan units down at PD?
Little traffic warden. Now, boys and girls, sir, this is what's gonna happen, okay? You guys are gonna put your tasers away, unlock every door for me.
That is not going to happen because you
You
have an
guys?
officer hostage. The door is unlocked.
Okay.
We will
now
let
this-
you out, but the tasers are
know
not
what to
going
do.
down
Tell me.
because you're threatening an officer. Simple.
That's fine.
Tell us if you can get
No, hey, everyone stay. No surrounding, no funny business.
Okay,
Open that next door and walk away from it.
You've got my permission to take shot. Make sure it's a clean shot.
Before he gets out, Cornby.
Come on. Next door.
Go on, my boy.
Is he shot Robinson?
No.
Nice.
No, I'm okay. I just
Take
stopped.
care, Robinson.
Oh.
You're good, Robinson.
My fucking guy. Come here, what's your number?
Now, I see some differences here. You state that you took your shot. However, in your video, that clearly shows you took your shot. Is that correct?
Yeah.
However, Officer Blades submits his video, and we can very clearly see 3 shots. One of which impacts the wall, leaving 2 others.
Right.
How do you justify this?
Sorry, you've completely lost me here.
Well, let me put
What's-
it another way. Your evidence differs somewhat from your colleagues, and I find it incredible that it differs at the exact moment that you pull the trigger and you...
I don't really understand how it differs when it's kind of pretty much the same footage, just his footage goes on about 5 seconds longer. My footage still shows me all the shots that leave my gun and Dion going onto the floor.
And your video quite clearly shows 1 shot, 1 sound of a gunshot. There is a marked difference.
Well, I can't really explain that one for you.
Well, the video submitted by Officer Blade clearly suggests an officer not in control, an officer in a frenzy, pulling the trigger at random, shooting at anywhere just to get the job done at all costs.
Well, I won't put it like that, man. I'd more say I've got someone who's trying to kill an officer and wants to be released into the public, so I put him down, which is my job, but it's in my job description.
At all costs.
Not at all costs. To make sure that the civilians and the police officers are safe.
So it doesn't really matter how you get the job done, provided you get the job done.
Objection, leading.
Overruled. Continue.
What we continue?
See to answer the question.
Oh, it doesn't matter in that way. What I mean is, we do our job how we're trained to do our job. How we're trained is if we've got someone threatening us life, and we believe it is a major threat to an officer or a civilian, we're trained to take appropriate action.
I see, and that is appropriate action, is it, to shoot into the wall and twice into a somebody in custody. That's the actions of a man under controlled emotions, is that?
Yes.
And evidence would suggest that is not.
Well, my bodycam footage and anyone else's footage from that scene has been checked off by Gold Command and Silver Command. So I would say that it is.
I see. Well, the fact remains there is a clear difference which has yet to be explained. Your Honour, I have no further questions for this witness.
No.
During my closing speech, I stated my case to the jury. This would serve as my final opportunity to sum up a case of police incompetence, incorrect charges, overzealous behaviour. I'm arguing that a string of charges have been issued with no substantial evidence shown by the prosecution. This resulted in a full acquittal for my client. This is a sad story of a man persecuted by law enforcement. The police department that issues charges on a whim, fabricates crime with no evidence, shows no regard for public safety, clearly ignores pleas for help, uses force on injured people, a firearms division with an overzealous, trigger-happy officer shooting a detainee and potentially altering video evidence. Members of the jury, if you believe there is substantiated evidence that links the defendant to these crimes, then you should return a guilty verdict. But if you see reasonable doubt, then you should find the defendant not guilty.
Okay, so I would like to just say to everybody involved in this trial, I express my appreciation for your professionalism and respect during the judicial process. To the members of the jury, I commend you for your conspicuous efforts in fulfilling your duty. Your commitment to the principles of justice and your careful consideration of the evidence are vital to the integrity of our legal system. Now we will begin with the verdict. On each charge, the charges brought against the defendant, the jury has found that the defendant not guilty. After careful deliberation and consideration of the evidence presented in this courtroom, the jury has determined that the prosecution did not meet its burden of providing guilt via a reasonable doubt. As a result, the defendant is acquitted of all charges.